It's a great pleasure to welcome you. I know we have a few people grabbing lunch, and I don't want to rush you. No rush. I want to welcome you to this talk in the Osgoode Colloquium on law, religion, and social thought. This particular talk is co-hosted, and I just wanted to say a word about that. We're delighted with the Colloquium to partner with a couple of different centers and organizations at Osgoode and elsewhere. And one of the great collaborations that has built over the last couple of years has been with the Religion in the Public Sphere initiative at the Department for the Study of Religion at U of T, and Pamela Klassen and her initiative have been really close workers with our colloquium, and really they're jointly presented now. And so delighted, of course, to have Pamela with us and a number of students from University of Toronto up to take in what promises to be a wonderful talk. This is also co-sponsored with the Osgoode's Institute for Feminist Legal Studies, and with thanks to the director of the IFLS, Sonia Lawrence, for the support for these talks and for coming up with all sorts of great collaborations and places for linkages between the IFLS, the Colloquium, and other places. The IFLS is such a hub of thought at Osgoode, and today's talk really reflects a number of the overlaps in the common concerns and common methods, really, of the variety of places that thought comes together at Osgoode. So in the Colloquium, hopefully this isn't your first. It might be your first. I hope it isn't your last of the talks in the Colloquium. I certainly won't be. You've seen this kind of march, I trust, of these provocative, interesting speakers really at the forefront of their particular areas in reflecting on religion, society, its interaction with law. And I'm terribly excited to welcome our next guest, who has made her own profound contributions to questions of religion, law, gender, known really for a very subtle and careful interdisciplinary approach to questions around constitutionalism, bioethics, religion. This is Professor Leslie Griffin, the William Boyd Professor of Law at UNLV. And I just want to embarrass her with a few words before I hand things over to her. As I said, with her PhD in religious studies from Yale and her JD from Stanford, the kind of foundation for the interdisciplinary kind of work that the Colloquium really tries to emphasize is expressed so beautifully in both the background and also the work that you see from Professor Griffin. She has made really celebrated, recognized contributions to the interdisciplinary study of law and religion. You see that in all of her work. Lots of focus on the ways in which religion is thought about carefully, while law is also taken seriously as a domain of social ordering, and with questions around gender infusing the work. I can commend a couple of pieces of her writing to you if you haven't yet had the pleasure of it. She has a rewritten opinion about the abortion funding case, Harrison McCrae, in a fabulous volume, Feminist Judgments, Rewritten Opinions of the United States Supreme Court. And I commend that to you. And a really rich casebook on law and religion, helpfully titled Law and Religion, Cases and Materials. But just I wanted to name a couple of pieces of recent vintage that Professor Griffin has authored that both Pamela and I just think the world of, and in fact drew us to thinking about inviting Professor Griffin here. One is a 2015 article in the Alabama Civil Rights and Civil Liberties Review entitled "A Word of Warning from a Woman, Arbitrary, Categorical, and Hidden Religion Exemptions, Religious Exemptions in LGBT Rights." And an article in a journal, Religions, entitled "The Catholic Bishops versus the Contraceptive Mandate." Today's talk, I think, picks up on a number of the themes that were at play in those articles around the institutional, the individual casting of religion, how we think about, approach, define religion within law, what the virtues and also risks are. And in Canada, where we're thinking about collective rights and collective and institutional protections of religion as a sort of growing and coming issue, this talk is a very important word from our neighbors. We have a lot to learn from the US experience. And so please join me in welcoming and thanking for coming from UNLV, Professor Griffin.
Well, do I need the regular microphone too? Okay. Well, thank you for the warm introduction, and thank you for being here to listen to me. I have an unusual goal with my talk today, and that is to say that you can't leave the room without your own future theory of what religious freedom protects. I say that as somebody who, when I was your age, thought the world would be a different place, especially for women's rights. And it hasn't gone as far as I thought it might go. And part of that is that some religions have not been big proponents of women's rights. And so already we see the tension that I'm concerned about, saying, well, I think in the United States, we like to think that what the framers of the US Constitution did all those years ago was do something really revolutionary. And that was one thing I discovered over the years of studying the First Amendment, is that when you look at what Professor Wood and Professor Lampert and others have written, they say, you know, at the time that the First Amendment to the Constitution was drafted, which says, right, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so the framers of the Constitution came up with these two religion clauses that have been struggling since then. And so you say, okay, the free exercise of religion, which people thought at the time was starting to be understood, right? All those people coming from Europe and other countries were saying, hey, we don't have any religious freedom. Our governments order us to belong to a religion. Our religions order us to do things, and so we don't really have free exercise. And so you had some of that carrying over to the United States, where the framers said, we need to have something in our Constitution that protects individual ability to practice religion. And then the framers added something even more dramatic, the Establishment Clause. So saying there can't be any establishment of religion. And often that's taken just to mean, oh, we can't have one established church like the Church of England. But there's always been that question, well, what did the framers mean when they set up free exercise and establishment? And the historians, some of the historians of the Establishment Clause say, well, what they really set up was a system of individual religious freedom, meaning that individuals were free from the power of the church or the state. And so it wasn't just the state that could keep people from exercising religious freedom, it was the churches as well. And so part of the history of the United States Constitution should be a fear of religion as well as a fear of the state, that either is dangerous when it threatens individual liberty. And if you believe some of the historians, that's the notion of the First Amendment that you'd like to have. But of course, our law has been much more complicated than that. And I'm going to explain some of that today. But as I explain it, remember that especially when you start studying law or start studying religion, you think, oh, there's one theory or kind of one understanding of religious freedom. But over time, what you realize is that in the United States, you have what? You have the Constitution itself. And then you have federal and state courts interpreting what the First Amendment means and coming to their conclusions. And sometimes if the legislators don't like what the courts are doing, they pass their own religion legislation. And then, of course, you have all these groups of people who are individuals, but also in large part members of individual religions. And so all these people start fighting for their version of religious freedom. And so what I'd say now is, right, we have maybe even a more traditional understanding of law and religion than the framers originally had when they drafted that First Amendment clause. Because if it's true that the framers were really focused on individuals, we've gone a long way in protecting the leaders of religions or the institutions of religions and believing that that's the best or even the only way to protect individuals. But when you look at what's happened now with the law, you see, well, there are a lot of religious individuals who aren't enjoying the full protection that the hierarchy of their church is enjoying. And that, to me, is a long-term problem, which I've worked for a long time to try to change. I've been on the losing side a lot of these cases for long. I can say, I've been there early. I've been there a long time. That's why I decided for this talk I would be unusual and say, well, instead of coming in and talking to you about all my work, I figure I'd tell you about it, but then say, well, my work hasn't taken hold yet. And a lot of women's work hasn't taken hold yet. Not all the men are on one side of this. And so what I'm going to do today is point to a few places of how you could understand religious freedom. And there's two cases where we think we see it at work. And that's the first free exercise case that the Supreme Court decided back in 1878 was a Mormon man who was arrested for bigamy. And he claimed as his defense that it was a religious duty to practice polygamy, and so he couldn't be prosecuted. And the court said, oh, no. Religion is not an excuse for breaking the law. You've got to follow the law. And so you see here this individual faced with the law, and the court says, oh, no, everybody has to follow what the court later called neutral laws of general applicability. If you have a religious reason not to, well, that's not how we govern. We govern according to our laws. And then in 1990, that case was picked up again when Justice Scalia wrote the Smith case. And the Smith case was about Native Americans who had used peyote in a religious ritual. But they were drug counselors, and they were fired for using peyote in a religious ritual. And so they went to court and said, oh, you can't do that to us, right? Just like the man with the bigamy had said, oh, you can't do that. My religion says otherwise. And in what turned out to be a very controversial opinion, Justice Scalia wrote a decision that says, oh, no religious citizen is above the law. Everyone has to follow neutral laws of general applicability. And so you can see it, right? You can see, well, it looks like the court is defending this idea that it doesn't matter what your religion is, the law you have to follow. But of course, it gets a little trickier if I say, well, it was, a Mormon in the 19th century and a Native American in the 20th century. All the cases look like that? And we say no, because we've had different battles about just how far that rule can go. And so when people read those cases, a lot of people say, oh, that's too negative, that's too strict on religion, and so we need to protect religions more. And we can see that same issue, right? A Mormon saying, but my religion says I should marry more than one woman. And a Native American saying, but my religion says I should use drug laws. And now where do we see the issues? We see the issue in the debate over same-sex marriage, where you say, well, on the one hand, it seems like, okay, now in the United States, same-sex marriage is the law of the nation, right? The court said that in the Obergefell case. And so, right, if you really believe that the rule is everybody follows the law, then it's not very hard. But of course, the Obergefell case, finding a right to same-sex marriage, was a 5-4 decision. And the 4 dissenters, in very strong complaining dissent, said, this court hasn't taken enough account of all the religious objection to same-sex marriage that there is out there. And so they better do a good job of making sure that enough people get exemptions from the law of same-sex marriage. And so here's where we are, right? Ideally, you'd think, oh, there's just a rule that says, well, people have to follow the law. But our First Amendment law is much more complicated than that. Because what happens is, I think we could probably say it for everybody in the room, when it gets down to something that's really important to you and your religion, it might be that you go out and fight for it and think, who cares what the law says? I want to follow my religion. And I think that's one way to interpret the US history of religion, is to say what we've had is different people from different religions saying, wait a minute, you can't ask me to, right? You can't tell me that. I get to follow my religion. And so that first ideal that the court had, that what we really cared about was individual freedom, has been lost a little because it's been official religious groups who've been arguing for most of the religious freedom cases. And the two places that they see that I talk about in the paper are on the so-called ministerial exception, right? This is court language, the ministerial exception to the First Amendment. And then second, the rule on contraception. And they're both cases that have affected a lot of women. Women who work for churches where they're not ordained, and some in which they are ordained, and then women who want to use contraceptives. So you'd think it could be easy, right? Just say, well, what are we going to do about people who work for churches? Well, they'll be subject to the law like everybody else. But that's not how it worked out. Because when the US Congress passed the first law, right, which said, okay, we want employment discrimination to be illegal. And so we got to figure out how to do this and what's the right way. And so there in Congress back in the 70s, they had this long discussion about, well, we want people to be able to be sued for discriminating against people. But, you know, if religions hire on the base of religion and hire people so if a Catholic institution hires a Catholic over a Baptist, what's wrong with that? That's what they should, right? So there's a sense of, okay, so the statute says that religious organizations cannot be sued for religious discrimination, but it also says they can be sued for sex discrimination, race discrimination, what's later interpreted as same-sex discrimination. And so you have a law that on the terms of the law, as it's passed and as it's still written, says that religious organizations can't be sued for religious discrimination, but they can be sued for the other forms of discrimination. Well, that's what the legislature wanted. But the cases got to court back in the 1970s. A woman who was actually a minister in the Salvation Army, right? So it wasn't a church that was saying you can't ordain women. They had ordained her, but they were paying her less than the men. So she went to court saying, hey, this is sex discrimination. And according to the statute, I can sue for that. The statute says what religions can't be sued for religious discrimination, but this is sex discrimination. And so way back in 1972, the Fifth Circuit said, oh, sorry, if we let you sue your church, we would be interfering too much in church decisions about ministry. And we don't want to do that. And so we hold that applying the statute to you would violate the First Amendment, and we create the so-called ministerial exception, meaning that ministers can't sue their employers. And then that went on till 2012 before the Supreme Court heard a case. And gradually, court after court, federal court, state court, one after another, said, oh yeah, we buy this ministerial exception too. And they applied it not only to Title VII, the federal discrimination law, but to the Disabilities Discrimination Act, to the Age Discrimination Act, to racial discrimination, every kind of discrimination. Eventually, one of those cases got to court, whether in a state court or in a federal court, and you had this growing body of case law that says ministers can't sue their employers. And finally, the case that got to the Supreme Court in 2012 was Hosanna Tabor. Now, Hosanna Tabor was just a Lutheran school teacher. Although she'd taken some courses in theology, so she was a called Lutheran school teacher and not a lay Lutheran school teacher. And she got sick and went on disability leave. But then she got better, so she tried to go back to work. So she goes back to her school and says, hey, I'm better, I'm ready to go back to work. And they didn't want her. And she said, well, you can't discriminate against me, that's disabilities discrimination. And so she went to court and argued, this is disabilities discrimination. And in the Sixth Circuit upheld her lawsuit, saying that, oh yeah, the courts could go through and figure out that she had more secular hours than religious hours and so forth. And so every once in a while you get a court that says, oh yeah, let this case come into court. We can, we're smart enough, we can figure this out. But that's not what the Supreme Court said. The Supreme Court, for the first time in 2012, which is a long time after the ministerial exception was first created in 1972, but in 2012, the Supreme Court unanimously, broke my heart, said that her lawsuit had to be dismissed under the ministerial exception, meaning dismissed, right? Not argued on the facts, right? All that the employer has to say is our employee is a minister. And if the court accepts that the employee is a minister, the case is over. So, and so you can see that if you counted up the cases, there are a lot of cases over the years where ordained women are dismissed, their lawsuits are dismissed on clearly, right, they're either priests or ministers. But then a lot of lay women, especially a lot of lay Catholic women, their lawsuits are dismissed because whenever they go to court, their employer says this employee is a minister. And most of the courts have bought that. Now, see, I'll admit, right, I mean, we can't all pretend to be neutral all the time. I mean, I was raised Catholic, brought up Catholic, went to Notre Dame when it first admitted women. I've been around, seen a lot of things. So I'm more, I couldn't understand, because I had this happen to somebody I knew back when I was at Notre Dame before the Supreme Court decided this case. She was just working, and a new pastor came in and fired her. And you're like, well, they should go to court over that. But the court said no. She's a minister. And she tried, long before the case went to the Supreme Court, she tried to argue, oh no, everybody knows that a Catholic woman can't be a minister because the Catholic Church doesn't ordain women. But the courts have said that's a theological question that we can't resolve. And so almost all the time when lay people get into court, their cases get disputed. Now, not every case has gone this way, right? Post the Hosanna Tabor case in 2012, you have all these cases. One case in Kentucky, seminary fired a Jewish man, and the Intermediate Appeals Court actually said that he was a minister. And he was kind of like, no, I'm not teaching any religion, I'm not, and you kind of read it and think, well, you could have worded that better. And finally, the Kentucky Supreme Court said that a Christian minister couldn't sue the seminary, but the Jewish professor could. So it's kind of, it's kind of some victory. And now in Catholic schools, there are a couple of teachers, but just a few, who are non-Catholic or whose teaching load is completely secular. If you're a good lawyer or you're going to become a lawyer and you want to be on the side, tell people their job has to be completely secular with no religion in it. And then you couldn't be a minister. But once you're leading people in prayer or helping with the retreat or doing who knows what, you could become a minister. And so it's odd to me to look and see all these lay people. Right now, there are a lot of Catholics in it because right now, the Catholic Church and a few others view this as a good time to fire gays and lesbians, who are more open now that they can get married. And so what you'd see is across the country, religious institutions are firing gay people and saying, oh, we don't want this person here. And if you go with the ministerial exception, that could be allowed too. Some of the bishops have been asking all their employees to sign forms saying they are a minister. And the teachers have fought back. And I'd like to remind you of that because I know in a lot of audiences it's going to sound like you're really hard on the church, but of course, there's two sides to the church in all these disputes, right? There's the employer and there's the employee. And what's happened in these cases is the courts have issued rules that basically say the employer wins. Because the other option is to let the cases go to court and let juries decide. And sometimes they'd find discrimination and sometimes they wouldn't. They'd go both ways. But with the ministerial exception, they go one way in favor of the employer. And so that's where I look and I think, if I really want to keep that original vision of the First Amendment that the historians talk about, where individuals really have liberty to join churches, to leave churches, to do what they want, I'm not sure that the ministerial exception really matches that, because all it does is it combines the power of the state with the power of the officials in the church and shuts out the other members of the church who are the employees, right? Most of them are members of the same church. Or they're working for churches that like to say, we will hire everybody. When you look at these cases, most of the cases, you'll see they've had anti-discrimination policies on their books. And they say, oh, we hire anybody, right? So the Lutheran Church that hired Hosanna Tabor, right? They had in their papers that they did not discriminate on any grounds. And so she brought that up in the case saying, hey, I'm a teacher who works for a Lutheran school, and look what they say. They say we don't discriminate against people, but they just fired me because I tried to come back from disabilities leave. But what did the court say unanimously? We can't get involved in these kind of religious disputes. It's too right? It's too religious. What will we do? And so now what you have is occasionally a case will sneak through, but usually only the easiest cases where the person fired is of a different religion than the person who fired her, right? When they're the same religion, it gets trickier, and you tend to defer to the employee. So that's one problem where I think, when you really look at what happened, it looked like the courts took one side of another in a religious dispute and just said, hey, we can't do anything, so we're going to let the employers do what they want. Now, the second issue is contraception. And contraception is an old famous issue by now, where the one thing we know is that, right, since they issued their first public statement in 1919, the Catholic bishops have opposed contraception, and they've been very consistent in doing that. And as the paper says, they were very consistent even in the 1960s, when back in the 1960s it really looked like the Catholic Church was going to change its teaching on contraception and say it was moral. It was kind of late, like the other churches had started to change, the Anglicans had changed, others had changed, and the Pope had a study group, and they wrote documents telling him he should change the church's teaching on contraception to say it was acceptable. Now, it probably could have been only acceptable for married people and so forth. It would have been pretty narrow. But Pope Paul VI read the documents and decided they were too liberal, too radical, too something, too unfaithful, in his view, too unfaithful to Catholic teaching. In his view was the Catholic Church has always been against contraception. And so in 1968, he issued the encyclical letter Humanae Vitae. And according to Humanae Vitae, contraception is immoral. And there's a huge split in the Catholic Church at this point, because most Catholics had thought the teaching was going to change, and they were using contraception. And most studies that are done say that Catholics use contraception in the same percentages as other non-Catholics, people of all religions or no religions, that the percentage of who uses contraception and who isn't is about the same across the lay world. But the bishops, they know what they're teaching. It's true. So, I'm sure you can be like, which side of this are you going to be on, right? So the bishops are saying, hey, we know contraception has always been wrong. It's something that we stand for. It's something that we're against. And we are never going to allow our participants to engage in it. And so you've got this very steady teaching from a very steady church. And yet you've got the members of the church who've been saying, well, we don't really care what the Pope said. We don't really care what the bishop said. I mean, I know it sounds unreal, but that's basically how it's worked out. A lot of Catholic women have used contraception and just disagree with their church, which is really all these are about, right? You've got two groups in churches, and they fundamentally disagree, with the official one saying it's wrong and the members saying, well, we want to use it anyway. So then what happened? Along comes President Obama and Obamacare. And as somebody who's not Catholic, I think President Obama wanted to find some good compromise at the beginning. So at the beginning he said, well, we'll want all employers to include contraception in their health insurance. That's part of what's included, right? One of his agencies said, when we put together what's covered, contraception has to be covered. And that, of course, would be the easiest way to leave it, right? Everybody who's got employees has to provide contraceptive coverage. But at first, Obama said, well, we'll give an exemption to churches. Well, the churches wanted more than that. They wanted an exemption for everybody. So at the beginning, the churches get the exemption, but then all the nonprofit and for-profit businesses across the country who aren't churches. So my alma mater, the University of Notre Dame, is not a church. But it led the litigation against the requirement, saying, you know, all the religious institutions had to be freed of this requirement because contraception is always immoral. And so what happened, right? So first, Obama gave the exemption to the churches. And then the for-profits got to court first. Everybody was kind of bickering behind the scenes, what would the rule be? The for-profits got to church with Hobby Lobby. And it's funny, you know, if you were listening at the beginning, you'd say, didn't you say that there's this two famous cases, Reynolds and Smith, right? The peyote case and the polygamy case, and didn't they say you just got to follow the law? Well, after Smith in 1990, the Congress was so mad about Smith, saying it was such a bad decision for religious freedom, that they passed something called the Religious Freedom Restoration Act. So it didn't matter, right? And so if you're a good lawyer now in the United States, you'll know anytime you go to court for religion, you sue under the First Amendment and lose. But then you've got the Religious Freedom Restoration Act, which puts the old test back into law and says, boy, if you burden somebody's religion, you're going to pay, or they're going to be exempt, or something's going to happen. And so Smith, the Supreme Court's case, says everybody has to follow neutral laws of general applicability. But the Religious Freedom Restoration Act says, oh no, if your religion is substantially burdened by a law, they've got to prove that they used the least restrictive means of achieving a compelling government interest. And for the lawyers in the room, right, for anybody who cares about language, that's the hardest test to meet in common law, the least restrictive means of achieving a compelling government interest. So this is what I meant at the beginning when I said, you've got religious arguments coming in from all places, because the court said, oh no, everybody has to follow the law. But then the Congress said, oh yeah, oh no, we'll make it easier on religious people. And it's because of that statute that Hobby Lobby won the Hobby Lobby case, right? Hobby Lobby, the employer that said, there are 4 of these contraceptives that we believe to cause abortion. We don't want to use those. And the court said, you don't have to. And so what happened now, the government's been kind of trying to figure out what to do, right? How they could provide contraception since the employer doesn't have to. So it's been another kind of, okay, Obama gave the churches an exemption from contraception. The court gave the for-profits an exemption from contraception. And then the nonprofits were still there fighting, right? Led by Notre Dame and others. They've been out there saying, hey, we want the same thing the churches got, which is a complete exemption. And Obama's kind of being nice, saying, no, maybe I can do something else for you, right? You just have to tell us now that you don't want to provide this, and we'll find some other way to do it. And the nonprofit case went to the court that way, with the nonprofits, and right, that's why on contraception, right, I mean, it's, in a way, it's really an easy argument for the bishops, because there's been no official change in teaching on contraception. So the minute they say we're opposed to contraception, everybody believes them. And so you're like, now what we do? Well, so Obama's saying, well, we'll keep finding different ways to exempt employers, leaving it to the government to get the contraceptive covered. And of course, once Justice Scalia died and we had only 8 justices on the court, those 8 justices sent a funny little responder back on the nonprofit case. They said, hey, we think that it looks like the 2 sides could come to an agreement. So we're just going to dismiss the case and say, hey, do your best to get an agreement on how on how women are going to get contraceptive, right? We know you can come to an agreement. And what happened is the court writes a short thing saying it looks like the 2 sides can agree and we're not going to have to resolve the controversy. But the discussion was open for a while. And then what happened? Somebody issued a brief saying, we can't reach an agreement. We can't reach an agreement because we just see things too differently, with one side wanting contraception and the other not wanting it. And so now we're stuck again. And As you might know if you read about the United States, who knows what's going to happen now, because we might be losing contraceptive coverage in the first place, right? Obamacare is now under debate. Even today, right, the Republicans introduced their new version of Obamacare. And so I'll say it's all open and up in the air now as to who's going to get what. But one of the important things that's happened throughout all these cases is that everybody's worried about how you exempt religions from the law. And over time, all that leaves you with is a bunch of different institutions following different laws. So it seems to me, and we're going to see that again in contraception. That might go away if President Trump decides that, and Congress decide that Obamacare doesn't exist anymore and contraception shouldn't be covered. That'll go away one way. But of course, the debate is just starting on same-sex marriage, where so many groups are saying, I'm a government official, I don't want to do a marriage. I'm a baker, I don't want to bake a cake for a same-sex marriage. And we've seen all the cases, and most of them are religious claims saying, hey, I don't have to follow the law. And what I think is that in the long run, that's going to be a dangerous approach, because all you're going to have is exemption after exemption after exemption. And so I say, looking ahead, and maybe way far ahead, who knows how many years it would take, I think we need something that's closer to what the founders gave us. And it seems that what the founders gave us is something that looked at individuals and not institutions. Whereas a lot of what we're looking at now is institutions. We look at prisoners as individuals, but most of the religion cases are brought by, quote, the spokesman or women for the church, who then get the ruling that they want for themselves. But it's not necessarily a ruling that does anything for their members who are trying to be good members of the church. And so I suggest that at some point in the future, the United States is changing, right, with more and more people saying they don't belong to traditional religions, with more and more people challenging them. And so who knows which way it's going to go. Right now we have a huge debate as to whether we're just a Christian country, what our view of Mormons is, right, lots of ways going. And so that's why I figured instead of spelling out the whole new theory for you, I'd say we're right in the midst of it. We thought it was a pretty intense discussion, and it's growing more intense when we're even deciding who can immigrate to the United States and who can't, and is it religion that's providing the grounds for that? I mean, many people think that that's clearly unconstitutional, but that's the discussion we're having. And I think it's, again, because for years now we've been so used to just letting the leaders of the churches speak that we've lost sight of the need to protect the individual freedom. And the government has too often just kind of sided with the official church instead of with the members. And so, right, you see even President Obama right at the beginning, like, oh, we'll just exempt the churches from contraception, because everybody in the church, right, actually, the first, they changed it, they took the wording out, but the first version did say, because we know everybody in the church has the same position on contraception. Right, and then everybody, even, you know, the conservatives kind of made fun of that, like, you know, what are they thinking, right? So the administration issues this thing saying, oh, we're exempting all the churches because we know nobody will be offended there because they all agree. And then somebody said, wait a minute, you don't really believe that, do you? Since the debate on contraception is one of the most intense we have in a lot of churches. And so there's been too much kind of, oh, whatever the leaders say, we'll go along with it. But in the long run, that probably doesn't promote individual religious freedom. So I'd like to see a wiser way for us to get there, to get back to the days when we said everybody has to follow the law. Now, of course, you know, the hope is that once you really take account of individuals, you'll take account of whether the laws are really secular or religious, right? Because if you read the Reynolds case from long ago, right, I see somebody shaking your head, right, there's an awful lot of anti-polygamy stuff, which we still have. I mean, that's always the interesting test case, right, is which way are we going to go on polygamy? Is there a neutral way, or is there only a religious way to go? But what I think we need in the long run is secular laws that everybody can follow. But right now in the United States, we're a long way from that. And I think it's in part because many of us are not willing to stop and say, oh, everybody shouldn't be forced to follow my religion, or I've got to think broader than my religion. I know the starting point for a lot of people is my religion teaches me X, and therefore X should be the law, and everybody should follow X. And that has a great appeal to it until you really stop and think of the diversity of religion across the American population and think, well, we really need something that's richer than this, that's going to allow everybody in. And over the long run, not allow all these religious institutions to just impose their law on their own people. So my hope is that late in life, when I'm retired and reading what you've all done, that you'll have come up with the ideal theory for how we can continue to protect individuals and not just their employers. So thanks for listening, and I'm happy to take your questions or comments.
So I left you some water there behind you. So what we'll do now is, in customary fashion, is we have these not to amplify, but to make sure that they're captured for our recordings, which you'll find from our past talks on the website. So I'm going to turn to the group now and ask what questions you might have, and I'll pass you the mic. Questions for Professor Griffin. I know I'm filled with them myself. But.
Uh-oh.
Comments, questions?
Hi, Professor. Just out of curiosity, in the Hobby Lobby case, were any of the for-profits arguing that they shouldn't provide any contraception, or was it like? Right.
So the one that it was interesting because the Supreme Court took the non-Catholic case, but then after Hobby Lobby was released, they sent back all the Catholic cases. So Hobby Lobby involved only people who were opposed to 4 of 20 contraceptions because they believed they caused abortion. But then they sent back the ones for the nonprofit companies that believed that all contraceptions are illegal, and they all won. So the nonprofits won on all their, the for-profits won. So Hobby Lobby's for-profit, the for-profit wins, Hobby Lobby for 4, then all the other for-profits win for 20, and then we go back to the nonprofits. And the nonprofit cases are still going through the courts, and most of the, 8 of the 9 appeals courts ruled against the employers. And yet one court went the other way, and so the Supreme Court took it. And so now they're all those cases are just stalled. Okay. And so we have to say, okay, some of them are decided, and so who knows what's going on. But technically they're just stalled because of reasons that are in the paper, right? The reasons that are in the paper is that one side was saying contraception is always immoral and you can't force us to participate in it. And the other side saying contraception is a fundamental constitutional right, which is what makes a big difference, right? You say, according to the same Supreme Court, women have a constitutional right to contraception. So how could it be that we're going to exempt all their employees from providing it to them? It seems, do you really want religious freedom to go that far?
Okay, I guess also I was just wondering, the test you described that the RFRA imposes today, it doesn't seem so far from, I guess, the Canadian test. Mm-hmm. It's minimal impairment and mm-hmm. a balance of interests. But in Canada, I guess these sorts of it seems like these sorts of cases still definitely go both ways. Like there aren't these sorts of arguments essentially. I was just wondering, I guess, do you think that also might just be in a part of American culture essentially, that it might be maybe a more religious place, or the sense of religious freedom is so much more. It's like First Amendment. It's so much more foundational to the country. Do you think there's any sort of cultural differences there that could explain that?
So of course the United States has the Establishment Clause, right, which is it's a huge thing, right? It's not a huge thing that's been enforced a lot, but it usually kind of starts to discuss, we've got to respect our Establishment Clause, and it seems that Canada has, without having it, has viewed things differently, and it seems to me right now that the Canadian cases are all over the place.
Yeah.
I mean, tell me if that's right, because I was
No,
kind
that's
of
definitely true.
trying to read through them, kind of like how would I talk about them if you asked me about them? And I think it seems to me that although some of them are decided differently, that a lot of the same issues are going on. And that's why it's really fundamental to decide about them, right? Because you've got religious groups saying, you know, there's two ways we could live together. We could live together with every religious group following its own teachings, exempt from many laws, most laws. Or you could say, well, no, we've got so many different religious groups now that we've got to move on to something else. And it seems to me that because of the changing cultures and the increasing diversity and difference among the cultures themselves, we need something that's more future-looking. It seems to me that some of the Canadian stuff now is the same kind of, well, past-looking, like how are we going to let all these people follow their religion without realizing, well, it's hard to hold the society together that way if more and more everybody's kind of divided. And I think you're having it now in the education area, right, where you say, okay, because in the United States, it was the Catholics who came in, right? Because technically, the First Amendment is supposed to be neutral. Then the Catholics arrived, and they're like, hey, this isn't neutral. We don't like your schools. We want our own schools. And so now the discussion that we're having in the United States is, oh, all the religious schools should get their own funding, and then we'll have a nice setup of all these schools, which might not be the ideal that the country wants. And it sounds like Canada's having that discussion too. What's it going to be? One neutral system that anybody can attend, or the breakdown into the only way to hold it together is to have all these different religious schools?
Bruce.
Thanks, Ben. Thanks, Leslie. That was terrific.
Thank you.
My question also very much from a Canadian perspective. And it seems to me that one of the differences between Canadian ways of talking about these issues and American, and correct me if I'm wrong, but my impression is partly because of the structure of the Charter of Rights and Freedoms, having guarantees of rights and freedoms, or at least protection of rights and freedoms, and then limits in Section 1. We're very used to thinking of the definitional issues and the issues of limits on the rights and freedoms as somewhat distinct stages. And I think that gives us a little more freedom to define the freedom, religious freedom, for example, more broadly perhaps than in American jurisprudence, or obviously very different historical circumstances too. And then a lot of the hard work gets done in Section 1, and much of it's relating to trying to resolve conflicting rights. And so whether we're in a charter context or in a different context, we're very used to a conflicting rights kind of discourse and methodology, and you're right, we haven't fully worked it out. But one of the things that's odd, again, from my limited knowledge of the US jurisprudence, from a Canadian perspective, is it doesn't seem to spend as much time talking about it, some of these issues as issues of conflicting rights. It's religious freedom and therefore protected, or it's not. Whereas we would say, yes, religious freedom is at stake, but so is sex equality, and what's the appropriate way to prevent both as much as possible and figure out how to resolve them when they do conflict in different contexts.
I mean, that's why it's so hard for me to see, first of all, the ministerial exception cases, where all those women who were really not ministers still get excluded from court without much discussion of what does this do to women and their women's rights. And so it is true that that's missing. And then the second thing, of course, is we're going back to the First Amendment, right, into a whole different time frame. And of course, one of the interesting things is, like I say, oh, when I read these, I was writing a brief for the Supreme Court and I was looking for information to support me. I read these historians who were saying the First Amendment is about individual religious freedom. But see, that's not the dominant approach to the First Amendment that the United States Supreme Court now takes, right? May he rest in peace, Justice Scalia and others gave us originalism, saying in a way, well, we've got to live the way we did then. But, right, that doesn't mean he wants the way my historians picked. He says, well, no, sex equality and all that wouldn't have the same importance that religious freedom was, right? But I mean, back at the time of the First Amendment, race discrimination and sex equality weren't treated the way they are now. And so if you're really a believer in the First Amendment, you're going to have ways that religious freedom trumps everything. And I think it's been this kind of, the government has kind of thought, well, some way we can find a way to take care of it, right? And that's what the Obama administration did. Like, some way we're going to find a way to get women contraception. But notice they haven't done, they haven't done it yet. They've had a while, right? The Obamacare has been there for a while. There's been all this sense of we've got to get women coverage for contraception, but why doesn't it happen fast? And I think it's because the religion people have the First Amendment behind them, and then to their credit, they're great. They've controlled a lot of the discussion. And that's why at the beginning when I said, I want you to leave here with your own theory of religious freedom, it's because if you don't have your own or thought about it, you're likely to kind of just think, oh, of course, right, X was right when they said that the churches should win. And then you have to kind of stop and really look into it and say, oh no, there's more going on here that nobody, right, that as much as we might think that women's equality matters, it hasn't. And who knows how much gay equality or transgender equality is going to count over against religious freedom, right? That's the new battle. And you say, okay, what's going to be over there? And you're going to have all these religious freedom arguments against gay rights. And there are a lot of people who want to make sure those rights win, that religious freedom trumps gay rights, which is something new.
Yeah, a lot of religious practices are carried out in association with others. Do people try to throw the right of assembly and other things like this into the mix?
Every once in a while we do. And I was in the court when for the ministerial exception case, and I had tried to say, oh, let's put everybody together under association, and the Solicitor General argued that in court that day, saying, well, it would be great, we could protect everybody under association, and the justices almost jumped off the bench at her. And so I think some people say that's a better place, and I like it. I mean, I like it as a place that everybody gets the same rights, instead of the religion clauses, which right now don't really protect everybody, right? You've got to have a certain good kind of religion. And so I'd say, the people with foresight are saying it or seeing it as a different route. But so far, the court doesn't want anything like that, right? Whether you're liberal or conservative on the current U.S. Supreme Court, even if you look at our prayer case, there's no longer a strict separationist on the Supreme Court of the United States. They're kind of mixed, or right? There's no, and there aren't any Protestants on the Supreme Court of the United States, at least right now. And so they've had a different notion, like religion is fundamental, the First Amendment is fundamental, it privileges certain groups over others, and that's what you have to live with. That's how they reacted in court that day. Like, oh, no, you're not taking religion, right? So the difference was, we don't want to be treated like other people. Religion gets special treatment. And that's why I say, in the really long run, can it really work? Because as long as religions get special treatments and others don't, you're going to have this kind of war of who knows what rights succeed.
Thank you so much. What an interesting talk, and you're really helping me think about a big case that's coming up in the Supreme Court of Canada soon that you may have heard about, the Trinity Western case, about whether a religiously based university can have a law school. And I'm really struck by your point that perhaps a religion is not just defined by the official doctrine of the religious hierarchy, but actually should be defined partly by what freedoms the members of the church want to have, to be able to attend a religiously based institution and be a gay or lesbian or transgender person. So that makes me wonder, does this sort of come back to political struggle within these religious organizations for kind of the right to claim what is the religion? What are the tenets of the religion that its members must be free to participate in? So that's as close as I can come to an actual question, but very thought-provoking.
It's interesting, when I've been reading about that case, it's very hard because depending on what you read about the schools, it's very different what they seem to be doing. And so I say, if they want students who believe or don't believe in gay rights, I can see that's acceptable, but I don't see that you can keep people who believe certain things from becoming lawyers. So that's where I think the problem is. You say, could we really authorize a lawsuit that says no gay lawyers, right? Right. So it seems to me there's some room to protect the religious freedom and to protect people who have certain views. But once you start saying no gay lawyers, in my view, if you're a lawyer today, you can't accredit a school that would say, well, some people who are legally allowed to be lawyers can't be, right? Because it's fundamentally at odds with the law. And that's the problem, right? I'm sure that some of you in the room who are very religious will say, wait, but religion is very fundamental. And yet I say, yeah, but the law is fundamental in a different way. And I worry that the law these days is so aware of how are we going to keep all the religions in, that they don't look carefully enough at what they're doing. So I'm interested to see what the court says about this. Is the school just saying we want certain kind of students, or is it saying we think certain people can't be lawyers? And that should be illegal for them to get an accreditation, right? They could run their law school as they want, but for the government to endorse, and see, that's what I think is really happening. Ministerial exception, the government is really endorsing these discriminations, right? The statute says you can be sued for this. And if the court says, oh no, you can't be sued, it winds up that the court is on the side of discrimination and not on the side of freedom.
Thank you very much for your talk. Coming at this from a religious studies perspective, we've been talking about how making religion only private is perhaps too reductive. So I was wondering, in your emphasis on individual freedom, what room is there for public religion within that conception of religious freedom? And particularly because in what we had to read for this talk, you mentioned public religious monuments and the court-appointed justice opinion on that. Mm-hmm. So I'd be curious to hear what you think about public religion.
All right, so I'm not a keen advocate of public religion, because the way we tend to be getting public religion is that the government kind of right? The government ends up saying, oh, right, we need to have prayer, right? Which that's the big loss in the United States, is the public prayer case. Or we need to have monuments. And it seems to me that the justices who are on the Supreme Court right now are very sympathetic to public religion and haven't seen how it can exclude so many people. So I'm not for going out and tearing all the old monuments down, right? Because at a certain point that's destructive. But I think you've got to kind of draw a line and say, we can't keep thinking that we're going to be a religious country. And and that's at the core of your question. If I say, we can't really think the United States is a religious country, I'd understand if you all start throwing things at me, because, but it seems to me that there is that core idea in the First Amendment that the laws that are going to govern us are not supposed to be religion-based laws, or they're not just supposed to favor one group over others. The founders came here trying to find a ground of compromise because they came from the wars of religion, which sometimes we forget, right? So the people who founded this country came from nations that had been consumed by violence for many years, and religions fighting to win. And they kind of shrugged their shoulders and said, we've got to find a new way to live if we want to live in peace. And I say, in the long run, look how we're living now in the United States, right? Wondering if immigration law is going to protect religious freedom or not. That, to me, is in the same theme as, if we all want public religion, there can be real damage. So I'd like to say that I'd want people to see that they might have more religious freedom if it were viewed as more private, instead of as a constant battle to control the public. That your private institutions might do more for you than you do if you're always kind of fighting for more public religion, more control of government, more public prayer. That it seems to me a lot of people have taken the wrong direction in that. And that in fact, right, there is nothing like private religious freedom. And that is what the First Amendment protects, right? Something that people didn't have in other countries.
Hi, so again, thank you for your talk. And I'm going to preface this with a few things. One being, I apologize if I misunderstood what you're saying, and that comes out of my question. And two, it's somewhat similar to the previous question, but maybe a little bit broader in scope. I'm wondering if the conception of sort of a private individual religion, or taking it out of the public sphere, what the public sphere sort of looks like. Do we then have to have a baseline agreement among these various actors who are trying to control sort of the public space and what religion looks in that, and is that even possible? And sort of how the conception of morality and the root of morality, where does that come from in a situation like this?
I mean, that's a great question. And again, I'll say, I mean, I feel like I understand it from one level because I was raised Catholic. I went to Catholic school. I went to Notre Dame. I majored in theology. I've studied a lot. And it took me a long time to realize that many of my Catholic friends and I all had this assumption that our religion was universal, right? That's what I learned in Catholic school, right? Is that you have a religion, you believe this, and a lot of your arguments aren't based on religious language. You say, oh, we don't need to talk about God when we talk about abortion or contraception or just war or anything, because we have all these principles. And so I had to learn over time that what we think of individually as universal principles might not really be that universal. It's a big stretch. I was influenced by the famous philosopher John Rawls at Harvard, who tried to get everybody to use public reason, to say, you're not supposed to, when you're living your public life, you're supposed to be looking for common ground with other people. And it's a very hard thing to do, because you won't get all your, and I think that's the thing, and it goes back to your question, you're not going to get everything you want in public. And I think that's what a lot of people haven't been ready to give up on, right? This idea of, I admire the United States because it sets up the system that finds common grounds among people of religion and no religion. I mean, that, right, in my view, that's the early ideal, right? And of course, there were failures in that early idea to include everything. But if you think the ideal is, we've got to find non-religious grounds that govern us, and then let other things stay free. But I think that we've been fighting for so long on religious grounds that everybody kind of does it now. It's very hard to go into a room, as I do all the time, and say, you know, the goal isn't for you to get your religion voted into law. The goal is for you to think what law rightly governs everybody. And it's a hard, right? It's a hard step. It's not something that you can just do in an afternoon, like, oh, I'm going to give up my religion. But I think it's an important step to say that if you want, in the long run, to find the common ground, people aren't going to have the law all based on their religion. And we're certainly not there now. And which is why I say, I think we need, for the future, we need something where people are more ready to give up their religion and say, oh, you know, I can't impose my religion on everybody, but we're not there yet.
Hi, Professor. My question is a little bit about the role of the judges in all of this, and the way that they kind of construct understandings of religion. So in Canada, we have sort of a body of jurisprudence where the judges are very hesitant to get into questions regarding, theology and religious dogma, and they've put that, the emphasis on that of the individual. And by contrast, I was really struck in your description of President Obama saying that, or his administration kind of saying that, the Catholic Church believes this and about contraception. And I'm just wondering, how do the judges take that in terms of when they're confronted by these theological questions? Do they look at the leaders and what they're saying, or, because it doesn't sound like they really take an individual approach, and I'm curious kind of what your thoughts on that are.
I mean, I do think that we're influenced by having a court of Catholics and Jews now with not one Protestant, right? Once Justice Stevens left, we didn't have a strict separationist anymore. And I think that if you look at the long, right, because, and Catholics, simply because of size, right? You can say other groups have done a lot, but simply, Catholics have been the biggest minority for a long time fighting for their way. And so I think that you have Catholic justices who understand that worldview or respect religion so much. So right now on the court, you've got Jewish and Catholic justices who respect religion so much that they don't want to offend it, and they don't want to even take it out of public life now, right? Or we have close votes, the close vote on the prayer case, right? Oh, prayer, right? The new prayer case says, oh, prayer isn't really prayer, it's just kind of a celebration. So if you have prayer at your town council's public meeting, it's not really defined, it's just kind of celebratory. That's what Justice Kennedy wrote in this opinion. And so I think that they are, I think that we all, and we'll say it's not just justices, we all are influenced by the religion that we bring to things, which is why I think it's hard to make the next step to say, could you set aside your religion, or say most of the time I'm not going to have my religion in law. Like that's a huge thing to say, and we don't really have justices on the court right now who are ready to go that far. You know, we have some, Justice Ginsburg every once in a while. Justice Kagan, not so much. President Obama, not so much, right? They're not really strict separationists. They're kind of, you know, pro-religion in a good sense. And so I think it's very hard to get back to the, you know, public religion could do some bad things. Right? People are afraid of that, right? If I say it right now, you might all go, oh, you know, don't say that, right? It's kind of, there's some things about religion that it's harder and harder to say. And I think it's because people, the institutional norm has caught on, and the people are so used to thinking of it that way that they don't want to say anything too hard against individual religion.
Thanks so much for the talk, and I'm going to admit that I haven't read the paper, so if this is in the paper, I know you will direct me to the paper. So I heard you offer two kinds of justifications for the more private vision of religion. And the first one was kind of the goal is to think about how we can all live together from different religious backgrounds, including no religious background. And then the other one was this Scalia-led ascent of originalism and this idea of where the founders would have, how the founders would have done the definition. And I'm hearing these as kind of, the one is the real thing, and the second one is the kind of doctrinal or advocacy-based position that you're asserting. And I guess, but I'm really curious about that second one, because again, in this Canadian context, the founders are still alive, at least the people that drafted these things, and so we have tended to really not engage in originalism at all. And I'm just wondering, given that you have other interests wrapped up in this, including kind of promotion of sex equality rights, and I'm sure kind of thoughts about other forms of anti-discrimination, how do you see the role of that kind of originalist argument and the potential dangers that it raises, and can it be confined? Because, yeah, I'll leave it at that. Do you think it can be
first of all,
confined?
let me be clear in saying that I know a few people have written books saying everybody is an originalist. I am not an originalist, and I admit it's because I studied religion before I studied law. Like a lot of the original stuff in religion is really not good for women. And so so I would criticize originalism because its effect has been to keep older stuff in place. So I'm much more for a living constitution where people vote and change and start accepting women's equality, start accepting racial equality, start accepting gay equality, transgender equality. You can't get to those places from originalism. And so I say, you know, to his credit or not, Justice Scalia was so influential on originalism that he got everybody talking about originalism, which means that now the Constitution, for many people, has become a way to try to insert the older views. Now you'd say right, most people aren't saying we want to assert anti-slavery, but see, the older view of religion can become a good thing, right? Oh, we're just asserting that we want to protect old visions of religion and old visions of, Scalia said that he would go along with women's equality, but kind of reluctantly, right? Because he doesn't think even the 14th Amendment protects it. So first of all, I think you have to learn to dismiss originalism because it's just an attempt to bring back older stuff. That you've got to have different ways of reading the Constitution. And that's why I like the historical point. So I like the historical point because I say, if you really look at what was going on in the First Amendment, it wasn't really about protecting the hierarchy of the Catholic Church or any other church or the Anglican Church or anybody. It was really supposed to be about protecting individuals from religious persecution. And I'm sorry to say that a lot of individuals in churches these days, I've met a lot of the people who have been fired and who've been thrown out of court and all that. And from their side, they feel like they've been persecuted, right? They were fired because they disagreed about something, or some of them were just fired because they were black or a woman, right? Some of these cases are bad. Not all of them. I mean, some of them are loser cases where people were fired for good reason, but others were really bad ones. And see, originalism hides a lot of that. So I'd rather say, and that's why at the beginning I said, in a way, I'm encouraging you to take it on because we're not there yet, but we need to look forward. And it seems to me forward right now is pro-women's rights, pro-African American rights, pro-gay rights, and finding a way to keep religions together and not having a constant battle about which religions can come into the country, who can sue. We've got to have a better way that isn't original at all. I admire the Famers because they actually came up with a compromise in very bad situations. But you can say, and that's the interesting thing in the history of the First Amendment, when you see what happens over 200 years, when you've got all these different groups fighting for their different positions and trying to get it to win. And you hope that someday we can do it a little better, right? So it's not a kind of constant battle for one religion over another. But we're not there yet.
So I wonder if I could ask
Sure.
a question or two just as we come close to the end of the time. And I suppose there's two faces of it. One is this is a really interesting talk at this moment in Canada, partly because of the litigation that Lisa mentioned, but also because we've moved from in our recent but earlier jurisprudence on freedom of religion to an extremely individualist focus that was then subject to a certain kind of critique that I want to ask you about, to a moment now when the court is for the first time really playing with the notion of recognizing through religious freedom that groups can hold or corporations can hold or entities, organizations can hold religious freedom. So we're at this moment when we think maybe the court is going to have to soon pronounce authoritatively on that group holding issue. And that's, I think, come from a place where the critique of the very individualist picture, which is the picture that you're kind of urging back towards, was something like this, that you actually will just miss too much about religious life. You'll misdiagnose what the sociological reality is about what the religion is you're trying to protect with the individualist focus. You lose a sense of the collective character of religion. You start deciding cases, arguably wrongly, because you're looking at the individual outside of the context of the web of relationships that they're a part of. And so it seems that part of the push in Canada to say, recognize the group, recognize organizations, is to say, I want to give greater regard to the kind of way religion is lived. And so one question I have to you is, how does one, is that a real concern with the push back to the full individual, or how do you budget for that in an approach? And I suppose the associated question is this, which is some people would, I think, put to your proposal or to your picture for the future the idea that it supposes that there is a place that law could occupy that wasn't a forceful intervention into religious lives in the world, and that what that end proposal is in a way, as you put it, individual religions kind of getting along. I think some probably would respond and say it's a recipe for the dismantling of collective religious lives. And that's really kind of what's happening, is that you say, well, I can either intervene on the side of the group, and you've critiqued all the reasons that we would be worried about intervening on the side of the group, in-group oppression or in-group discrimination. And then we're troubled about the individual. But if we intervene on the individual, then we're empowering that at the expense of the community authority structures. And so is that just a way in which law has no choice but to intervene forcefully in the group? And here what you're talking about is a kind of legally sanctioned picking away at the structures of religious life. So they're kind of the same question, but they're just put in two different ways.
So I think, if you think of the kinds of cases, so if we go back to the employment discrimination one, and I say, okay, what the court has said is there's a rule that just dismisses the lawsuits. And I don't want that rule. I want the cases to go to court. But having said that, I've acknowledged that you win some and you lose some, right? That the employees are not going to win all their cases. If you read the facts of these, some of them are really bad cases. Some people were clearly fired for good religious reasons. They weren't doing their job well. And so I'd say, I think in the long run, that kind of case should go to court because it protects both sides. and lets people see what's going on. Now that might be uncomfortable, but of course it'd be uncomfortable if the employee wins or the employer wins. I think they'll come out different ways. Now on contraception, I think that I think one of the issues that's a problem is, it's a good thing at the beginning when you say what we're really protecting is worship, right? People in Europe didn't even have worship. And so we're like, you got to be able to worship as you want. You can't have a church ordering you to worship anyway. You're free to have that. And then say, well, in some ways it's a long way from worship to a nonprofit or for-profit business refusing to provide contraception. And there I say, nobody's forcing anybody to use contraception. But they would say, you have to provide it. And that might make everybody in here feel uncomfortable, but I say, yeah, this is the way we have insurance set up now. It would be better just to let employees have access to it and make the decision whether to use it or not. And that's more important than this idea of, I don't want contraception in my health insurance system, right? That we can't have all our health insurance systems determined by religious principles. So I think you're right in that I would be taking some areas out of the religious freedom area. But that is in part because many religions now have not only churches, but they have schools and they have hospitals and they have everything. And so if you let all those institutions, like if you let all the religious hospitals in this country, or excuse me, back home in the United States, refuse services and say, no abortion, no contraception, no sterilization, right? None of this, you're going to have too much of an anti-law system. And so I'd say, yeah, I want to take some of the religious freedom away in what looks now like it's pure religious freedom. But being an employer in a nonprofit or for-profit shouldn't be viewed as a complete matter of religious freedom, as the Religious Freedom Restoration Act does now.
Well, I think we're at 2 o'clock, and I'm just certified to thank you present. So I hope, I know you'll all agree, lots of interest and a wonderful way to thinking through some of the issues that are certainly on our minds in Canada, and as we look around the world, to have that incisive view into what's happening in the dynamics in the United States, to draw those themes out is incredibly useful. And so on behalf of the IFLS and the Religion and Public Sphere Initiative and the Colloquium in Osgoode, I just want to thank you, and I hope you'll all join me in thanking Professor Griffin.
Should I open it or no?